This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions about workers' compensation. An employee that gets hurt on the job won't be able to work. How do they get paid? How do they pay any of their bills? If you've suffered through that, you've had work-related injuries, this is your chance to call in and ask your questions. This system is designed to protect both the employers and the employees, but many employers don't fully understand how the system works, and those who do sometimes take advantage of employees that don't understand how the system works. So if you file a claim, okay, first off, how do you do it? Are you in trouble if you don't do it right? Has your employer discouraged you from filing, or even told you you can't, or fired you for filing? Tonight's your chance to call in and ask your questions. The 31 Law Call number, 256-536-0077. You can call in and be live on the air, or you can also text us to that same number. You can also email your questions. You send it to lawcall@waytv.com, and when we get to a show that's on point, we pull some out. We've got some of your questions tonight. William Meservey is here from Timberlake, League & Brooks. Good to have you here.
Glad to be here, Sharon.
You guys do workers' comp, but they also do all kinds of personal injury cases, including something like, we've got some video tonight. We like to pull out some video. You make the law call. You take a look at what's going on here. So hopefully our stormy, icy weather is behind us here. But you get something like this where you get a pile up and you start asking, you know, are you always that one? Are you always at fault if you're the person who hits somebody from behind?
It's hard to figure out where this one begins and ends, frankly. And it, you know, is really just a series of ongoing collisions. I would say that the majority of icy road collisions that you see do not involve quite so many vehicles, right? Particularly around here. One of the things that a lot of people fail to realize is that the speed limit is not the only indicator for what the speed on the road is.
Okay.
What the law actually says is you can go the speed limit when the road is in an acceptable condition to go the speed limit. But you have a duty not to travel at a speed that exceeds the appropriate speed for the conditions of the roadway. And so when you look at a road like that, you know, with obvious ice and difficulties and problems with it, you know, there's going to be a duty there to travel at whatever the safe speed is to where you don't lose control of your automobile. But trying to sort out liability in a puzzler like that is going to be quite the task, right? And so, you know, that footage obviously wasn't shot in Alabama, but, you know, it would depend on the state that you were in and what that state's laws were. You know, but I would assume that the vast majority of those people are going to hope that they've got full coverage because it's going to be hard to pin that on just any one person. Hard
to figure out whose vehicles would be where, so you might not ever, I bet you would never have a full diagram of whose car was where to know who was in front, who was in back, because by the time the weather lightens up, a bunch of those cars are going to drive away, and
that's right.
What's left?
That video is just pure chaos. But, you know, typically, you know, in those type situations, you want to travel at a very safe speed, you know, slower than the speed limit, particularly, you know, somewhere like Alabama where we don't get a lot of ice on the roads.
Yeah.
And so we don't have a bunch of snow shovels out there. We don't have a bunch of salt on the road, you know, and to their credit, I think Huntsville does a really good job with that. Yeah. But, you know, it's some of these states operate
They just keep going, right?
They just go through it. So I'm glad we don't have to deal with that on a routine basis here.
Our northern neighbors make fun of us for Alabama travel. So tonight we're talking about workers' compensation. So workers' comp is an insurance. How does workers' comp work? Who is this supposed to protect?
Yeah, so it's really a compromise. And so it goes back to the Industrial Revolution. You had all these people coming off farms to work in factories. There was no OSHA. And you had a lot of people getting hurt, maimed, or killed. Now, if those people could prove that their employer had failed to provide a safe work environment, that was the common law theory of negligence, then their families would be okay. They'd get these big settlements and they'd recover for things like pain and suffering and mental anguish and all the things you can typically recover for in a common law injury case, whether it be an auto accident or premises liability. But the vast majority of the people could not prove it was the company's fault, and their families would go hungry. And so labor and management came together and developed what is known as the workers' compensation system. And unlike other types of injury law, this is codified law. That means this is law that has been passed through the legislature down in Montgomery. And Alabama's workers' compensation system is based off Minnesota's. And essentially what it does is it says, look, those big settlements, they're going away.
Okay.
All right, there's no pain and suffering, there's no mental anguish in a workers' comp case. And in exchange for that, you don't have to prove liability. So you don't have to prove that it was your employer's fault that you were injured. You just have to get injured in the line and scope of your duties. And there are some exclusions there, right? If you're engaged in horseplay or you've failed to obey safety regulation and were injured because of it, if you're intoxicated on the job, these are some defenses that employers may have to a workers' compensation claim. But by and large, if you're injured in the line and scope of your duties, whether it was your employer's fault or your own fault or nobody's fault, you're going to be able to recover certain benefits. And those benefits are typically limited to medical treatment, but that medical treatment's for life as it relates to that particular injury.
Okay.
You're entitled to permanent partial impairment or permanent total disability at the end of the case. When you've reached maximum medical improvement and the doctor says you're all better, you're as good as you're going to get. And for the time that that doctor has held you out of work, maybe following a surgery, you're entitled to something called temporary total disability. That's 2/3 your average weekly wage for that time that the doctor has you pulled out of work. Now, there are some other benefits that sometimes come into play, like vocational disability.
Okay.
You know, if you're not able to go back to your job and you can't find a job making a same or similar wage, then your employer may owe you more money than they would someone who is able to go back to their job or earning a same or similar wage.
Does this pay well?
No.
Or, no.
No, it does
really,
not.
no.
Because it is codified law down in Montgomery. Alabama's workers' compensation laws haven't been updated since the late 70s. And as a result of that, one of the multipliers that's used in calculating the value of your case is $220. Well, in 1978, $220 was the average household median income for the state of Alabama. But no one has updated that in Montgomery. And so as a result, your claim is worth the same in 2025 as it was in 1978, even though the dollar is not worth the same. So
Wow. Okay.
Not fair compensation.
You're not going to get rich off of this?
No, ma'am.
Okay. So if you get hurt on the job, are there certain things you have to do? You have to report it to somebody, right? Is that very strictly monitored?
It is. So there are certain things you have to comply with. Now, first of all, your employer only has to provide workers' comp coverage if they have more than 5 employees. So there are some very small businesses that purposely keep their numbers below 5 to avoid having to pay for workers' compensation insurance coverage. But as long as your employer has more than 5 employees, they have to provide this coverage. Likewise, you have 5 days to report an injury. You know, there are a few exceptions to that with occupational diseases. So for hearing loss or, you know, something like that that's not
that builds up.
Carpal tunnel syndrome, something that's not an acute injury, meaning, you know, fast happening injury. But for any sort of fast happening injury or acute injury, you have 5 days to report it to your supervisor. This can be actual notice, meaning you wrote it down on a piece of paper, which is what the law actually says. Now, the courts have upheld that oral notice is fine, so just telling your supervisor counts. But there can also be constructive notice. So if an ambulance pulls up, you know, to peel you off a machine and take you to the hospital,
notice.
The law says they have constructive notice.
So call in your questions, the 31 Law Call number, 536-0077. You can call in. You can also text to that number. We got this email question from Joe. Joe says, I injured my hand on the job that required surgery and time off from work for 8 days. My workplace says they're not going to pay me for the time off. Several lawyers have said my workers' comp case is too small for them. So where do I go to get help in getting my pay? Would they have to pay him for the time?
If the doctor pulled him out of work, and it would have to be your authorized treating physician, right? Because in workers' comp, you don't get to choose the doctor. You have to treat through workers' comp doctors. And so if that authorized treating physician pulled you out of work, they're going to owe you that temporary total disability. Now, I believe the law says that the doctor has to pull you out for at least 2 or 3 days before they owe that money. But in that situation, they would. If it's a scenario where you can't find someone to represent you, you know, you can always contact our office. Where, you know, I make it a point on those small cases to still pursue them, because, you know, there are unfortunately some employers who do try to take advantage of that system.
Yeah.
But, you know, you can always contact the Department of Labor as well, Alabama Department of Labor, and make a complaint through them, and they'll do an investigation as well. The state provides ombudsmen who assist through, they do various different things to include mediating cases.
Okay.
And
so
they provide that benefit for free.
Yeah.
And so there are things that can be done, but they would owe that money. Now, hands and feet, and remember, this is statutory codified law down in Montgomery, right? So there's something we call the Schedule of Injuries, and the law explicitly addresses certain injuries, and it addresses almost every sort of hand and foot injury you can imagine, because those are the most commonly injured body parts, as you can, you know, pretty well guess. You know, and it designates what everything is worth, right? So this finger might be worth 23 weeks, right? This finger might be worth 36 weeks, right? This hand might be worth 54 weeks.
Wow.
And so it gets kind of wild, but there are lawyers out there who don't like handling hands or feet cases because the law values them so low.
Okay. We're going to take a break. We will be right back answering more of your questions. It's Workers' Comp Night. We are also opening the phone lines up for any kind of legal question you've got, and we'll be right back. Call in.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. Tonight we're talking especially about workers' compensation, but you can call in or text in any kind of legal question. The 31 Law Call number 536-0077. You can be live on the air or you can text us. And we got a text question, this one. If you were on workers' compensation while employed and later retired from work, are they still responsible for the injury and taking care of your medical bills? What action can you take to open the case?
Yeah, so this is going to really boil down to what did you do at the time that you resolved out your case, right? And so there are some people who elect to close out their future medical benefits in exchange for more money. Now, those particular people are going to have removed any sort of responsibility off their employer from ever having to pay for medical treatment again. But even if that's the very, you know, if you leave your medicals open during the closure process, and so you have medical treatment for life as it relates to that particular injury, it does not matter if you never go back to work at that employer. It only matters that you were working for them at on the date that you were injured. And so the way that you go about doing that is you will have to contact the workers' compensation carrier that was responsible for handling your claim. That can be difficult to remember sometimes. And so sometimes you have to pull your court documents from the state, right, and figure out who was handling your claim so that you can figure out who to contact. The other option is if you remember the doctor's name that treated you, you can reach out to them and they will get in touch with workers' comp to get authorization to see you again. So there are a couple different ways to go about it. If you had a lawyer that handled your claim for you, the easiest thing to do is pick up the phone and call that lawyer, and he will have those records and he will know who to get in touch with in order to get you back to the doctor and get you seen again.
We've got caller Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, if on if a civil case on appeal is partially reversed and remanded with instructions, does the trial court have to hold a brand new trial, or can they just amend their judgment?
Yeah. A lot of cases get appealed, right? And
They do.
the appellate court hands something down. If they say they remand it and tell you to fix something, what happens?
That's right. So, you know, that case is going to go back to the judge, right? And he's going to have to follow the orders of the appeal court and what they said. And if they remanded it for a new trial, there's going to have to be a new trial. Now, depending on what type of case that is, they may not have to try the whole case, right? It may just be trying one aspect of the case that the appeals court found a problem with. So that's really going to get fact specific on, you know, what the order was, what the judges on the appeal court said, and what type of case you're dealing with.
Okay. We got this email question. Let's see, who is this one from? This one was from Morris. Morris had written in, I work for an oil change shop. An employee intentionally and willingly left a puddle of oil on the ground and then clocked out and went home. Another employee who's a friend of mine was returning to his station and slipped and got hurt. He was later fired. What can he do about his injury now? Also, is it defamation if an employer gives a false reason for termination? Because my friend was a good employee.
Well, Morris needs to get in the business of writing law school questions.
It is a
what he needs to
complicated
get in the
one.
business of doing. So when you kind of peel back the layers on his email question, if a co-employee intentionally or willfully does something to cause your injury, right, that can be an exception to a workers' compensation claim.
Okay.
Now, how's the employer going to prove that he intentionally and willingly left some puddle on the ground for you to fall into? So it would require that co-employee saying, hey, I did that on purpose just to get you, right? So if that were to happen, that co-employee might have created a situation where you may not be entitled to workers' comp, but you may be entitled to sue your co-employee directly, which typically you cannot do because workers' comp has something called the sole and exclusivity provision, which says that your sole and exclusive remedy for getting injured on the job is workers' compensation. Now, there are some exceptions to that. And this could be one of those type exceptions. The most common exception that you see is, what we call a third-party incident. And so that may be, I drive a truck for George's Widgets, and I'm going through an intersection, and someone from Mike's Widgets crashes their truck into my truck. Well,
you're on the job.
I'm on the job, right? So I'm going to get workers' comp. They're going to pay for my medical treatment. They're going to pay for my medical bills. But as you remember, what we talked about earlier in the show, there is no pain and suffering or mental anguish or those other type of damages that you can collect in a third-party case over on the workers' comp side. So you also have a third-party case against Mike's Widgets for, having run the red light or whatever it was they did to cause the collision. And so you actually have two cases in that scenario. Well, they play off of each other, and your workers' comp coverage might get to subrogate against that third-party case. Well, what does that mean? Subrogation is just a fancy legal word for I want my money back. And so anything they pay out for your medical treatment and your lost wages and everything else, they might be staying there with their hand out to get paid back out of that third-party case against Mike Widgets. So it can get very, very convoluted. But let's assume that, the co-employee in this email didn't say, ha, 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 I did it on purpose. And the employer's not going to be able to prove that this guy intentionally left this puddle there. That's a case that you'd typically be able to get workers' comp benefits for.
Gotcha. Talk a little bit about the third-party kind of cases. So the car accident case like that. Do you have one lawyer? Does one lawyer handle both these kind of cases, or how does all this work out?
You can have two separate lawyers. You can hire one lawyer to handle your workers' comp case and another lawyer to handle your third-party case. But oftentimes it's in your best interest to hire one lawyer that does both those areas of law and can handle both those cases. Because a lot of times there's some, in every type of case involving a workers' comp and a third party, there's a lot of strategy that goes into, well, maybe we don't pursue everything on the workers' comp side. And in exchange for that, the employer waives $30,000 of medical subrogation that you get to keep over here on the third-party case instead of having to pay them back.
Gotcha.
So there's a lot of strategy and thought that goes into how those cases play between themselves.
Okay, you were talking about some new case law with long-term disability policies, maybe starting to dip back into things.
We're starting to see this, particularly with some of the auto manufacturers, you know, and when you have a company that provides you long-term disability coverage, which is great, right? But if that employer is paying for that long-term disability coverage, and you get injured in such a manner that you go through your short-term disability to where that long-term disability actually kicks in.
Yeah.
A lot of those contracts say that the long-term disability carrier gets their money back. They get to subrogate against your workers' compensation benefits.
Oh, gee.
Which we've already discussed can be...
Wasn't much anyway.
Already not very sufficient for what you've been through. Now, the good news there is you're getting those benefits along the way from the long-term disability carrier, which is great. But earlier in the show, you know, you talked about how sometimes employers take advantage of the system. One of the ways that I've really seen them do that in the past 2 to 3 years, it has really ramped up, is when you get injured on the job, your employer a lot of times now will force you to take your FMLA leave concurrent with your workers' compensation leave.
Really?
Yes.
Are they allowed to do that?
They are allowed to do that. And now there's only one reason why they would do that. And that is so that when you reach maximum medical improvement, you're now able to come back to work.
Okay.
Right?
Yeah.
Well, you know, if you've been out for a couple surgeries and different things and you've run through your FMLA leave, you finally get to come back to work, but you now have permanent restrictions because you've injured your back or something else.
Yeah.
And they decide, well, you know what, we can't accommodate those restrictions.
Okay.
Well, now you can't go on to FMLA while you continue to recover, and they can just terminate you.
Sneaky.
Yeah.
Okay. We've got Carl on the line with a question from Huntsville. Hi, Carl. What's your question tonight?
Hi. I was wondering if a person suffers a mental health condition due to a high-stress job.
Yeah.
And they're forced to take time off because of that condition. Are they eligible for workers' comp?
Good question. There's a lot of stressful jobs out there.
Potentially.
Okay.
Potentially. But not from high stress alone.
Okay.
Not that I've seen. I have seen where you witnessed an explosion at work.
Okay.
And I've seen workers' comp carriers cover mental health following that. Certainly anytime a serious injury is involved.
Okay.
I've seen them pick up mental health benefits.
Interesting.
Head injuries, they'll typically pick up mental health benefits. But just from stress alone, I have not seen an employer in Alabama pick up workers' compensation and provide mental health benefits. They typically fight mental health benefits if it's a more minor injury physically.
Okay.
But if you do have or witness something at work that is likely to bring some form of PTSD, some sort of, you know, serious incident, then, you know, it is possible that your employer would provide you with some benefits like that.
All right. We're going to take a break. Be right back answering more of your questions about workers' comp. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with William Meservey. He's with Timberlake, League & Brooks. They are personal injury attorneys. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And family law attorney Sharon Doviat, handling everything from divorces, child custody, adoption. She's here in Huntsville. 256-539-7337. And you can learn more about her at www.sharonfamilylaw.com.
Thanks for all your calls and questions. Stay safe this week.
Have a great night.